I guess the point of this video, which I'm going to tell you right at the very start, is to remind you that when you're involved with family court, and if you find yourself involved in family court proceedings, you're in control. Run the intro. I'm going to use a specific case, happened fairly recently, where we here at McKenzie Picave were representing Mum, and there was a legal practice, solicitors, who were representing Dad, and between us there was a lot of banter going backwards and forwards over the course of a number of months. This is ahead of the very first hearing, what we refer to as the FEDRA, the first hearing dispute resolution appointment. So before that has even started, before the first time we've stepped into court, there's a lot of banter going backwards and forwards between myself and my client, which is Mum, and the solicitors and their client, which is Dad. The solicitors are taking quite a high-handed approach in terms of the fact that Mum has chosen to use McKenzie Picave, a professional McKenzie friend practice. They find that they're quite derogatory about it throughout the whole process. They were incredibly derogatory about the fact that Mum was using a McKenzie friend. But there we go. That's a subject for another day. So we are warming up, let us say. The two sides are gathering forces and we're warming up for that first court hearing. And there's a bit of backwards and forwards. We said that, you said that, we said this, you said that going on. Dad and Mum are communicating over and above this process, over and above the legal process. They have a conversation ongoing. They're talking obviously about the child who's in question. Although that conversation is quite heated at times, quite derogatory at times. So it's not healthy. It's not a health. The whole thing is not particularly healthy. We are 5 days away from the first hearing, and Dad contacts Mum, and just to let her know that obviously the first hearing is in 5 days' time, and he's been told by his solicitors that basically very, very little will happen, that the matter will be formally presented to the court for the first time, that we will all observe the Kafka safeguarding letter, which in this instance says that there are no safeguarding issues, and then we'll all go off and come back again in the second hearing and maybe do something a bit more productive. That is the view that he has. That is the view he's been given by his solicitors. Mum arrives to have an appointment with myself 5 days prior, and it happens to be a Friday morning that she arrives to see me. And we're chit-chatting, and she's quite anxious about the forthcoming hearing, and she's a little uncomfortable with the prospect of having to be in court, and a little uncomfortable with having to be in quite a confrontational environment. And clearly, from the correspondence that had been going backwards and forwards between ourselves here at McKenzie Picave and the solicitors in question, it was clearly going to become quite confrontational. And that's sad, that's unnecessary, because theoretically the point of the professionals is to guide the parties towards the best interest of the child, not to involve themselves, not to become gladiators in the battle. Anyway, so I'm explaining to Mum about the first hearing, the FEDRA, and my opinion is not dissimilar from the solicitors in terms of what will happen. But then I throw this into the mix. I said to Mum, do we know what Dad wants by way of contact? Do we know what he wants it to look like? And she said, well, no, not really. You know, he sort of refuses to say. And I said, well, that's a little odd. I said, because obviously one of the options that we have available to us, I said, is that we can bypass the solicitors and go direct to Dad and say, what do you want? Ask the question. And then between us, possibly, we can carve out an agreement, a consent order, which removes all the contention, removes all the conflict, removes all the confrontation ahead of this first hearing. And Mum said, well, is that something that's feasible? I said, it's perfectly feasible. I said, at any point in the court proceedings, in the family court proceedings. I said, you can present the court with an agreement that you as parties have reached together in order to end those proceedings. Now, as I explained to Mum, solicitors, in my experience, are not over keen on that to happen, because obviously that curtails the process. If it curtails the process, it curtails the fee. Here at McKenzie Picave, we work on a slightly different premise because our priority, our ethos, is not steeped in fees. Our ethos is actually steeped in the best interest of the child. And I have always been of the opinion that our objective is to close proceedings as fast as we possibly can in order to remove this horrible environment, and it is a horrible environment, to remove this horrible environment from around the child or around the children. So I make this proposal to Mum. I said we could approach Dad. She said, well, he's not going to talk to me, but you're welcome to try. So I prepared an email of some early thoughts on how we could reach an agreement, and I sent that email to Dad. Now, I also sent that email to Dad's solicitors, so they were aware of the fact that we were having this conversation, that we had approached their client direct. I'd done that out of courtesy. That email went out on a Saturday morning. So over the course of Saturday and Sunday, unfortunately the solicitors were closed. We here at McKenzie Picave are open and accessible to our clients 7 days a week, but unfortunately the solicitors were closed. So they couldn't partake, and that's unfortunate. So between ourselves, me and my client, Mum, and Dad, over the course of that weekend, we carved out an agreement. It wasn't easy. There was a lot of toing and froing. There was a lot of back and forth. There was a lot of trading, a lot of bartering in order to achieve what ultimately became a really very nice, very comfortable framework for the child to operate within, where both parents felt that they were represented. And both parents felt that they had the opportunity to co-parent in quite a healthy way. So we put together, at the back end of the weekend, we put together the draft order. I then communicated with the solicitors to say, look, we've done this over the course of the weekend. You know, you probably just want to give your client, you know, your view, just so you feel you've been involved. And then we'll submit it as a draft order into court and close this federa before it even starts. The 2 days, the 2 days between sort of the back end of the weekend and the hearing were interesting. The 2 days were Mum being perfectly comfortable, perfectly relaxed, because she appreciated that we'd now struck a deal. She knew that we had a deal that the child was going to be more than comfortable with, because the child gets to see Mum and Dad. The child gets to spend time with Mum and Dad. We had carved out holiday arrangements, we'd carved out Christmases, we'd carved out the whole shooting match. It was a very, very detailed framework. So Mum was quite happy. Dad was quite happy, but then Dad then started to communicate with Mum, and it's the first time they were communicating probably civilly for a number of months. Dad started communicating with Mum that his solicitors had a real issue with this order, and his solicitors were advising him not to agree to it. They were advising him that they could get him a better deal. They were advising him that if they allowed the process to run, they could achieve a better end result. And that, well, it upset Mum. It disturbed me. And I spoke again with Dad and said, look, are you happy with this deal? He said, I'm perfectly happy. I said, then we push ahead. We submitted a draft order about an hour before the federa started, federa, first hearing, dispute resolution appointment. So about an hour before, we submitted a draft order. We'd copied in the solicitors. The legal advisor, and that particular hearing was being presided over by a legal advisor. The legal advisor sort of opened the hearing and said, okay, obviously there's only one legal in the room because, you know, McKenzie friends, we're not legal, let's not kid ourselves. So there was a legal in the room, that's the solicitor representing Dad. So the legal advisor invited that solicitor to explain where we were. And she's probably expecting, here's Mum, here's Dad, they don't like each other, they've got these issues, we're going to try and sort it out over the course of the next few months. He said, the solicitor, well, we were heading towards a situation where we've got a mum and dad in contention. However, over the course of the last few days, mum and dad have been working with a McKenzie friend, and the phrase was spat from his mouth. Working with a McKenzie friend, and have arrived at an agreement, to which the legal advisor said, well, that's admirable, that's very positive, that's tremendous, that two people can work together civilly and arrive at an agreement. And the solicitor then went on to point out all the reasons why the agreement had no grounds in law and frankly should be dismissed by the court. To be fair to the legal advisor, and I have a view about legal advisors and judges and magistrates and who it is that they favour in a courtroom, but that's a conversation for another day. On this occasion, to be fair to the legal advisor, she very kindly said that she had little or no issue with the draft order that had been submitted, and she was quite happy to sign it off, seal it, and publish it, given that mum and dad had basically built it between them. And so that was it. The hearing was over. Mum and dad got what they wanted. Mum and dad have now got on with their lives, and the new order is working perfectly well for them. They both have the comfort of having a court order in their hand, but what they also have is the comfort of knowing that they arrived at the conclusion together. So, what is the point of all of that? What is the point of me telling you that story? The point of me telling that story is to remind you that if you are in family law proceedings, regardless of whether you're represented or by solicitors or whether you're supported by a professional McKenzie friend practice like ourselves here at McKenzie Picave, you are the client. You are in control. If you don't like the way a process is going, if you feel that the process should be accelerated or indeed slowed down, you are in control and you have the right to do that. In this instance, we gave mum the opportunity to say, listen, we don't have to follow this well-trodden path. We can try and accelerate this process and see if we can get between you and dad some common sense and sort this issue out. And we did. You're in control. It's your legal battle. It's not the solicitors. It's not their role. Their role is to act on your behalf, and that is the key. And here at McKenzie Picave, we do act and support on your behalf. But always know that our objective, as I said at the very start of this, our objective is always to move these proceedings as quickly as we possibly can in order that we can remove children from this contentious, wholly unnatural environment and allow them to go back to a carefree, innocent childhood with mum and with dad in the mix. Thanks very much for watching. If you want to learn more about Daniel Picave Counselling, watch that video. If you want to learn more about McKenzie Picave Family Law, watch that video. And remember to subscribe, because 68% of you haven't. See you next time.